This is Karina Norberg representing Big Bank in this matter. It is our understanding that on January 1st, 2014, Big Bank and Punk Brew Pub authenticated a security agreement to secure a $200,000 loan. In this security agreement, the pub, as the debtor, encumbered all equipment, inventory, accounts, chattel paper, and instruments then owned and after acquired. The parties also agreed on a future advances clause by which any and all additional loans would also be covered under the original security agreement. Prior to signing this security agreement, Big Bank had already filed an authorized financing statement at the corresponding office in this state. This financing statement complied with all the requirements to be effective. As you can see in the document, the name of the debtor and creditor are correct, and the collateral was properly described as all assets, with the intent to cover not only the assets indicated in the security agreement, but any other present and future assets owned by the pub. Regarding the first loan, Section 9, 317A2 establishes that a security interest that is perfected before a person becomes a lien creditor has priority over the lien creditor. In our case, the bank's security interest on Punk Brew Pub's assets was perfected on January 1st of 2014, when the bank issued the first loan that gave value to the security agreement also authenticated that day. Therefore, it is out of discussion that Big Bank's security interest has priority over the lien creditor's lien regarding the first loan. Now, with respect to the second loan, as you have manifested, Frederick Hawkins, Big Bank's general counsel, was informed about the jury verdict of January 29, 2018 against Mr. Sain and the pub. But you must acknowledge that it was not until February 5th that you obtained a judgment lien against all existing equipment of Punk Brew Pub. During this time, the bank had been evaluating a second loan for the pub, which was eventually issued on March 6, 2018. This was a well-thought decision on the part of the bank with basis on the protections provided to us by the UCC. Section 9, 323B establishes that any advances a secured party makes within 45 days after a person becomes a lien creditor is superior to the lien creditor. This 45-day protection is absolute and does not depend on the secured party's knowledge of the lien. You may argue in court that the bank was informed about the jury verdict, but you would have to admit in court that the second loan was issued within the 45-day protection period granted by Section 9. Despite knowing that, by law, the advance made by Big Bank on March 6 has priority over Ms. Koshka's judgment lien, we are also aware that Punk Brew Pub's assets are not going to increase after having filed for bankruptcy. As of today, Punk Brew Pub only has $749,000 value in equipment, and our goal is to come to an agreement with Ms. Koshka without having to take this matter to court. To achieve a fair settlement, while Big Bank would like to fully recover its first loan, it might be willing to make adjustments regarding the total amount owed for the second loan. That said, I will leave this proposal under your consideration and we will continue discussions. Thank you.